My today's topic is China's international law and order, a case study of South China Sea and Indian Ocean region. Now I'll share my presentation. All right. So, for many in China, the time has now come that there is a sense that China deserves a much stronger and more respected voice in discussions surrounding the future of the international system in recent speeches of Xi Jinping in Davos and Geneva in January 2017. Which suggests that China is now seizing the initiative and fighting for the voice and influence consumers with its status and power as a #2 economy in the world. But there is an interesting divide in the areas in which China chooses to assert itself in traditional areas of international law, such as the law.
Sneha, hello.
Yes.
Sneha, can you just maximize the size of your PowerPoint? There's a button on the bottom right. You can make it full screen.
Okay.
Or you can go to slideshow, and I think you can check the options there. It'll give you full screen. You know the slideshow on top,
Yes.
the menu? Yeah.
Remote control. Just a second.
Otherwise, it's okay. You can carry on. I don't want to waste your time. Go ahead. You can just carry on. Sneha?
Hello.
You can just carry on. It's okay. No problem.
Yeah, there is some discrepancies in the network.
Yeah, that's fine. You can just go on. Sorry. Yeah.
Okay, but there is an interesting divide in the areas in which China chooses to assert itself in the traditional areas of international law, such as the law of sea, or China continues to harbor reservations about the fairness of the existing international order. Its misgivings are fueled by a perception that it did not play a significant part in the creation of post-Second World War international order, and that those rules operate mainly in the area interests of Western powers. There's also a sense that traditional areas of international law do not offer a level playing field for China, since Western states have far more experience at operating in those. We know from the Chinese experts that in the South China Sea case, one background issues that played into China's refusal to engage in litigation with the Philippines and other interstates, which are represented by leading Western international lawyers, was a lack of experience before international courts and tribunals. Contrast this with newer areas of international law, such as the deep sea mining issues. In this area, the rules are still in the process of being developed and tested, and the influence of the existing powers is not firmly established or accepted. So there is more opportunity for China to voice to be heard and heeded. China has taken a keen interest in the regime applicable to the mining of the international seabed, making submissions to the International Tribunal of Law of the Sea about the procedure of setting disputes. So for China's practical input, international long-term setting has been limited. While China is prone to making wide-ranging statements of principles, it finds it more challenging to engage in nitty-gritty of a specific rulemaking. But as it is clear that China can adapt quickly, for example, it was a reluctant dispute settlement mechanism. China is now adept at making active and effective use of its rules to promote China's interests, including launching a legal challenges regarding the contested issues. So China sees international law as an important instrument in the toolbox of international diplomacy. It will increasingly by seeking a leverage to international law to promote its own interest, particularly to newer areas, as it seeks to strengthen its wider soft power and influence. So we can say that for decades, Beijing has complained that global order was forged in an era when China was weak and the rules of the game was rigged against it. But this lament is more difficult to sustain in relation to the United Nations Convention on Law of Sea, which China helped negotiate in 1970s and early 1980s. Beijing signed the treaty as soon as it was opened for signature in 1982 and ratified it in 1996. The Philippines initiated this arbitration against China in 2013 as a part of long-running dispute over the rights in South China Sea, including over the Spratly Islands. Now, they are known as Nasha Islands in China and surrounding maritime areas. Under the treaty, China is not obliged to defend the case, but this is not bar proceeding and it remains legally bound by the award. From the legal perspective, its refusal to participate is thus a risky move. All the more so since the ruling is likely to have legal ramifications for China's highly charged maritime disputes with other neighbors such as Vietnam and Malaysia. So, in significant concessions to those on the losing side of the argument, however, China publishing a position paper setting out its objections to the jurisdiction of the tribunal and formally conveyed this to the tribunal, which treated it as a effectively constituting plea on jurisdiction. So this form of non-participation or non-participating participation must be seen against the backlog of the strategic ambitions by China to develop greater mastery of international law. Also, the Communist Party called for China to strengthen its discourse power and influence in the international legal affairs and use of legal methods to safeguard its sovereignty, security, and development areas. So maritime disputes are a major impetus for this drive. For years, the Chinese governments have fretted about these low capabilities in the international legal field compared with the other permanent members of the United Security Council and regional rivals such as Japan. So now, impelled by the need to protect its strategic interest in the South China Sea and elsewhere, it is doing something about it. So in the arbitration and otherwise, China has avoided clarifying the precise legal basis and implications on its nine-dash line claims, which sponsoring a vast industry of academic studies to support its position. So while China's rejection of the South China Sea is true to form a powerful state that like its great rival in the United States, along with the United States, is generally ill disposed toward binding the international disputes resolution processes. It is not inconceivable that this approach will give way when China becomes more confident in its ability to play a win lawfare. Basically, the award issued by the arbitral tribunal in the South China Sea case has been tremendous blow to China. For years, China maintained a vague and unsustainable claim to unspecified historic rights with the zone delineated by the nine-dash line encompassing almost entire the South China Sea. It safeguarded its interest by calling for bilateral negotiations in its disputes with other adjacent states, including the Philippines, and was happy for negotiations toward even a mere code of conduct to procedure a very snail space. So the immediate question is whether these findings will have any tangible impact since China is not willing to comply, or it could also be argued that the award lacks legitimacy because the integrity of the proceedings has been damaged by China's non-participation, even if it did make some of its views known to the public records and by informal communications with the tribunal and its members. In the long term, however, China should be expected to carefully study the award and come up with a more major response. China still sees itself as a relative newcomer to the international law, lacking experience and confidence with regard to dispute settlements. So eventually, any flaws which may be presented in the award can be remediated, or in negotiations which take the findings of the arbitral tribunal as a starting point. Without ever formally acknowledging the validity of the award, China can make gradual adjustments to its position to accommodate its finding and resolve the underlying sovereignty and other disputes in the South China Sea. and which were not addressed by the tribunal. For now, the tribunal's finding will cause pain in China, but it may also contribute to China's further integration into the international legal order also. So that we have to consider. So the proceedings were taking place against a background of fluctuating tensions and continued anxiety in the South China Sea, where China and the Philippines, Vietnam, and other states have long been advancing opposing territorial claims and accompanying rights to exploit the maritime resources. So in the map, we can see that clearly. In recent years, all these states have been ramping up activities to assert their respective claims in spite of declaration of conduct signed in 2002 by China and the member states of the Association of Southeast Asian Nations, that is ASEAN, which calls for self-restraint. Negotiations for a code of conduct have been going on for many years without any result. So China's increased activity in South China Sea has been worrying its southern neighbors as well as the United States and Japan. China has long asserted a wide-ranging but ambiguous claims based on so-called nine-dash line or nine-dotted or U-shaped line in South China Sea rooted in historical arguments. The dispute between the Philippines and China has its origins in competing claims over the Spratly Islands. The Philippines initiated case in 2013, framing it not by reference to the islands themselves, but in terms of maritime jurisdiction. In an attempt to circumvent the restrictions that China has placed on its acceptance of UN clause dispute settlement procedures. So along with its legal challenges, the Philippines has mounted a diplomatic and media offensive to draw attention to China's non-participation, presenting itself as a small, law-abiding country and standing up against a big regional bully. So there are serious questions whether these historic claims are tenable under a modern law of sea in addition to China's claims may be difficult to prove. The current Nandash line was originally asserted as
Sneha,
an 11 dash line.
Sneha, can you take 2 minutes to wrap up, please?
All right, all right. So I'll point out the crux. So the principle expressed by China would refashion law as a tool for the imperial power that is consistent with the notion of ruler-based orders. So the main point here I want to mention that since 1978, China has actively joined intergovernmental and non-governmental organizations. The deepening bilateral and multilateral relations between China and Russia, Central Asia, the Association of ASEAN, African countries, the European Union, South Korea, Japan are these examples basically. So this evolving procedure represents China's attempt to rebuild its international image, to work within international norms, to pursue its interests and enhance national security. It also shows China's efforts to hedge against American influence. More importantly, it signals China's emergence as an active player in international areas, specifically the South China Sea. So here are some points that India should consider to act like a soft power hegemon in Indian Ocean region. Like China is seeking to unchain itself from what it sees as a shackles of Western culture and military economic dominance. So in this case, Taiwan is a last outpost of pre-communist China, which acting as what Beijing believes as a link in claim chain holding it back from the border specific. So China is claiming first island chain in nine-dash line, the second island chain, the third island chain compassing Alaska, Hawaii, New Zealand, fourth island chain as Pakistan, Sri Lanka, Maldives, US, UK, and the fifth island chain from Djibouti to the past Madagascar and South Africa. So important thing is the UN clause system of territorial waters, exclusive economic zone, continental shelves, claims based on historical rights. And by rejecting the nine-dash line, the tribunal is specified that the principal states that cannot set the boundaries of their fishing grounds based on maximum historical rights. So India must have to consider that in Indian Ocean region also. So important point is Chinese claims to fishing rights in the Andaman Islands or Sri Lankan claim to fishing rights in southern Indian waters. So we have to consider and we have to think about China from their point of view. Rocks can't be turned into islands and used as a basis of for altering maritime baselines. And here question arises, what if Pakistan chose to build out sandbar south of Karachi in an attempt to alter the orientation of the Indo-Pakistani maritime border because they are having nexus with China. And most important is, in the South China Sea and most standoffs in the Southeast China seas involve law enforcement vessels, not navies. Again, this is tactic that could easily spread to the Indian Ocean region. India must have to consider these policies also. And in conclusion, I would like to say that China's model for law at home and China's agenda in international law are, in terms of their content, which are undemocratic. And China's embrace of international legal norms that do not support democracy is a long standing. And China's ability and will to influence international law have been rising. So India must consider China from their point of view to secure Indian Ocean region basically. Thank you.